Thank you. Thank you so much for the kind introduction and the warm welcome. It's truly my honor and great pleasure to be with you. I come to you as a former high school social studies teacher, unless it expires. I'm still certified to do that in the state of Illinois, and I come to you as the son of a Teamster. This is a very frightening time for labor in the United States Supreme Court. This is a very frightening time for labor throughout the United States. What I want to do is talk about where the Supreme Court is now and where it's likely to go, especially when it comes to labor. The first observation as you think about the current court is that it's the Anthony Kennedy Court. I know out of tradition, in deference to the chief, refer to this as the John Roberts Court, but at least from the perspective of lawyers who stand before the just and write briefs to them, this really is the Kennedy Court. Last year, once more, Anthony Kennedy was the justice most often in the majority. He was the majority in 97% of all of the decisions. This was true the year before. He was in the majority in 98% of all of the decisions. In fact, even if you take out the unanimous cases, he's still by far the justice most often in the majority. He was in the majority in 93% of all the non-unanimous rulings. So when I talk to lawyers who have cases before the Supreme Court, my advice to them is, make your brief a shameless attempt to pander to Justice Kennedy. If the clerk of the court will allow it, put Anthony Kennedy's picture on the front of your brief. Second important observation about the current court, Justice Neil Gorsuch. The most important thing to happen in the Supreme Court in the last year is the confirmation and swearing in of Neil Gorsuch as an Associate Justice on April 6, 2017. We should pause, though, for a moment and reflect that what's occurred with regard to Supreme Court nominations in the last 2 years is unprecedented in American history and will have long-term consequences. Prior to 2016, 24 times in American history, there was a vacancy near the last year of a president's term. In 21 of 24 instances, the Senate confirmed the nominee. In 3 instances, the Senate denied confirmation. Prior to 2016, in the nomination of Chief Judge Merrick Garland, never before had the Senate said, no hearings, no vote. Now, I should pause here and disclose to you that I've known Merrick Garland since we were competitor high school debaters in the Chicago area. We also went to law school together. He was a year ahead of me. The morning that he was nominated, my oldest son called me and said, "You've known him a long time. What do you think of him?" I said, "He's a brilliant man, truly a decent person." And I said to my son, look at it this way. Merrick Garland is a Jewish man who grew up in Chicago. He had Eastern European grandparents. He was a high school debater. He went to Harvard Law School. I could also add he was 5'7", has gray hair, and wears glasses. I said to my son, what's not to like about all of that? As a result of what occurred in blocking his nomination, I think from now on, when the president and the majority of the Senate are of different political parties, the president will not get anyone confirmed during the last 2 years of a term. Given the electoral map, it seems unlikely that the Democrats can take the Senate in November 2018. But if they do, we need to make sure that they do not confirm anyone that Donald Trump nominates for the Supreme Court during the last 2 years of this term. What occurred with regard to the nomination of Justice Neil Gorsuch is also unprecedented in American history. Never before had there been an actual filibuster of a Supreme Court nomination. In 1991, there were 48 votes against the confirmation of Clarence Thomas, but the Democrats didn't filibuster. In 2006, there were 42 votes against the confirmation of Samuel Alito, but the Democrats didn't filibuster. The Democrats did filibuster the nomination of Neil Gorsuch. I think it was to express the message that this is a stolen seat on the Supreme Court. The Republicans then changed the Senate rules to eliminate the possibility of a filibuster for Supreme Court nomination. As a result, any president now who has a majority of the Senate of that political party can get anybody he or she wants confirmed. There is no doubt that Neil Gorsuch is going to be a very conservative justice on the court. In the now almost years since he's been there, he has consistently voted with Justice Clarence Thomas and Samuel Alito, the far right, on every ruling, on every issue. And keep in mind that Neil Gorsuch is going to be on the Supreme Court for a long time. When he was sworn in on April 6th, he was just 49 years old. If he remains on the Supreme Court until he's 90, the age was just John Paul Stevens retired, he will be a justice for 41 years. That would mean he would be justice into the year 2058. As I've said to my students, they can think, but a large part of their careers and their lives, there will be a Justice Neil Gorsuch. Third observation about the court. This is going to be a very bad year for labor in the United States Supreme Court. The case that will affect you most is Janus versus American Federation. To put this in context, a context I'm sure you're familiar with, in 1977, the Supreme Court decided Abood versus Detroit Board of Education. There, the Supreme Court reaffirmed that no one can be required to join a public employees union. But the court said that non-union members can be required to pay the share of the union dues, the so-called fair share, that goes to support the collective bargaining activities of the union. The Supreme Court explained that non-union members benefit from collective bargaining. They benefit in their hours, their wages, their working conditions. The Supreme Court said they should not be able to be free riders. The court said, though, that non-union members cannot be forced to pay the share of the dues that go to support the political activities of the union. The court said that would be impermissible, compelled speech. This has been the law now for over 40 years. Tens of thousands of contracts between government entities and public employee unions have been based on it. In the last decade, though, in a couple of cases, the 5 conservative justices then on the court sharply criticized Abood. In Knox versus SEIU, and then more recently in Harris versus Quinn, 2014, these 5 conservative justices indicated likely willingness to reconsider and overrule Abood. In fact, Justice Alito's majority opinion in Harris versus Quinn read for the first few pages as if the court was going to overrule Abood, but then he distinguished and limited it. A lawsuit was filed here in Orange County, California, to be the vehicle for overruling Abood. As you know, it was Friedrichs versus California Teachers Association. It involved a middle school teacher here in Orange County, Rebecca Friedrichs, who objected to paying the fair share, the part of the union dues that go to support collective bargaining. Her lawyer asked the federal district court judge in Santa Ana, Josephine Staten, to overrule the Supreme Court's decision in Abood. Judge Staten explained she's a lowly trial court judge. She couldn't overrule the Supreme Court. And Friedrich's lawyer said, that's right, just rule against us so we can get to the higher court. They then went to the United States Court of Appeals for the Ninth Circuit and asked it to overrule the Supreme Court's decision in Abood. The Federal Court of Appeals said, not even we, the Ninth Circuit, can overrule the Supreme Court. And they said, that's right, rule against us so we can get to the higher court. The Supreme Court granted review in Friedrichs versus California Teachers Association. It's an unusual case because it came to the Supreme Court with no record. It was just a vehicle to let the court overrule Abood. The case was argued on Monday, January 11th, 2016. I have never read a transcript of an oral argument that was clearer as to what the result was going to be. Now, one of the 5 conservative justices on the bench, Roberts, Scalia, Kennedy, Thomas, Alito, asked a question or made a comment that left a doubt as to how he was going to vote. I can only imagine how the lawyers on both sides felt on Saturday, February 13th, 2016, when they learned that Justice Scalia died. For lawyers, for union members, there's an enormous sigh of relief. There's no doubt that overruling Abood will be a serious blow to public employee unions. We've seen this when states have adopted right-to-work laws. We've seen the effect in terms of union revenues and union membership. And of course, for the National Right to Work Committee, this was what they perceived as certain victory being snatched away. Everyone knew that the fate of Abood, the fate of fair share, would depend on who won the November 2016 presidential election and who replaced Justice Scalia. Quite predictably, the Supreme Court dismissed Friedrichs, announcing that it was split 4-4. That means that the lower court decision stands, affirmed by an evenly divided court. But as everyone expected, there would soon be another vehicle for the Supreme Court to consider overruling Abood, and that's Janus versus American Federation. Here, too, the National Right to Work Committee asked the Federal Court of Appeals, the Seventh Circuit in Chicago, to overrule Abood. In a single sentence, then Judge Richard Posner said, Abood is the law and binding on this court. Now, we know going into the oral argument in Janus that the justices are split 4-4. There's no reason to believe that any one of these 8 justices has changed his or her mind from 2 years ago. That then means that the outcome of Janus rests on a single person, Neil Gorsuch. So, you might wonder, what questions, what comments did Justice Gorsuch make in oral argument? How can we infer what he's going to do? He didn't say a word at the oral argument. He knows that everyone is looking at him. I'm not a betting person. Even when I go to Las Vegas, I don't gamble. But if I were to wage a bet, I would wage all the dollars and pennies in my savings account that Neil Gorsuch is going to join together with Roberts, Kennedy, Thomas, and Alito. I think everyone, liberal and conservative, labor and management, has no doubt that the Supreme Court is going to 5-4 overrule Abood. The bottom line of this is going to be that the only First Amendment right that public employees will have is the right to not pay their fair share. The Supreme Court has taken away all of the other rights from public employees. And I think that this is the first of many blows to public employees and private unions that we're going to see. At the oral argument, Justice Kennedy was focusing on, shouldn't overruling Abood be extended to the private sector as well? And in his questions, he developed a theory as to why private sector unions should have to follow his same view of the First Amendment. I think that the challenge for you, the challenge for all public employees unions, is how to deal with the almost certain outcome in Janus. Is the solution members-only bargaining? And even here, there are other challenges in the pipeline. There are a number of cases now pending in the lower courts challenging the constitutionality of provisions of the National Labor Relations Act that create exclusive bargaining for unions. Non-union members are trying to claim that they should have the right to bargain, that they shouldn't, based on the First Amendment, have to have exclusive bargaining. That, of course, is a core provision of the National Labor Relations Act. Is the Supreme Court, based on its First Amendment jurisprudence, going to put that in jeopardy too? There's another case pending before the Supreme Court that I think is also going to be a blow to unions. And this was argued the first week of October. It's under the title Epic Systems versus Lewis. It's one of 3 cases that were consolidated for oral argument. It involves a different provision of the National Labor Relations Act, one that protects the right to engage in concerted activity. This is so important in the National Labor Relations Act that individuals cannot contract it away in their agreements. And yet the argument is being made to the Supreme Court that an employer should be able to insist as a condition for hiring that an employee agree to individual arbitration, giving up the ability to have a class remedy, giving up the ability to engage in concerted activity. Here, too, I've read the transcript of the oral argument, and my prediction is pessimistic. I think the Supreme Court's going to say that if an employer wants to insist, as a condition on hiring, that there be individual arbitration, the Federal Arbitration Act controls that this provision of the National Labor Relations Act has to give way. And so that's why I say that this is such a troubling time for labor before the Supreme Court, and I worry that it's not going to get any better in the foreseeable future. But let me move to a fourth point about the Supreme Court, and that's that this is going to be a blockbuster term in the Supreme Court. And some of the rulings, though not directly about labor, are certainly going to have implications. Let me point to three other cases that are pending right now in the Supreme Court that you should be aware of. One of the areas that's now before the Supreme Court concerns the constitutionality of partisan gerrymandering. I think that partisan gerrymandering is an enormous threat to our political system. We all learned in civics that it's supposed to be the voters who choose the elected officials. But because of partisan gerrymandering in all the states where it occurs, it's the elected officials who get to choose their voters. I think that partisan gerrymandering contributes enormously to the polarized political environment. And this is the most polarized political environment since at least Reconstruction. The statistics about this are startling. The most recent opinion polls with regard to favorability for President Trump show that 80% of self-identified Republicans give him a favorable approval rating, but this is only I think it's 5%, not 5 people, among those who identify themselves as Democrats. I recently saw an opinion poll that said that 11% of the population in this country still would disapprove if a member of a family married somebody of a different race. But 40% of people in this country would disapprove if a member of a family married somebody of a different political party. The challenge to our democracy is how to deal with this polarization. And I think that ending partisan gerrymandering is an essential step. Partisan gerrymandering is nothing new. It takes its name from a Massachusetts governor early in American history who engaged in the practice. As you know, it's where the political party that controls the legislature draws districts to maximize, say, seats for that party. But because of sophisticated computer programs, partisan gerrymandering has become far more precise than ever before. One of these cases comes from Wisconsin. Republicans got a slim majority of the votes for the state legislature, but then drew election districts to give themselves a sizable Republican majority in both houses. In North Carolina, where I lived for a time, it's basically a purple state. Republicans got a slight majority of the votes cast in the state legislature, drew the districts to give themselves a supermajority, both houses in the North Carolina legislature. In Pennsylvania, again, it's a purple state, generally a bit more blue than red. Because the Republicans took the state legislature, they were able to give Republicans 80% of the congressional delegation from Pennsylvania. In 2 cases before the Supreme Court, Gill versus Whitford, which was argued the first week of October, and Benesek versus Simone, it's about to be argued, the Supreme Court has considered whether federal courts can hear challenges to partisan gerrymandering, and if so, when it's unconstitutional. I think that these are the most important cases before the Supreme Court regarding the democratic process at least since Bush versus Gore on December 12, 2000. A second important case that's before the Supreme Court this term that could have widespread effects is Masterpiece Cake Shop versus Colorado Civil Rights Commission. It involves a gay couple in Colorado. They went to Massachusetts to get married. This was a time when there wasn't yet marriage equality in Colorado. They came back home and they wanted to celebrate their wedding with family and friends. They went to a local bakery, Masterpiece Cake Shop, a corporation, and asked the owner, Jack Phillips, to design and bake a wedding cake for them. Jack Phillips refused. He said that it would violate his religious beliefs to have to bake a cake for a gay couple. Colorado, like California, has a law, public accommodation statute, that prohibits business establishments from discriminating based on race, sex, religion, or sexual orientation. The couple filed a claim against the Masterpiece Cake Shop in the Colorado Civil Rights Commission. The Colorado Civil Rights Commission ruled in favor of the couple and against Jack Phillips in Masterpiece Cake Shop. The Colorado Court of Appeals affirmed. The Colorado Supreme Court denied review. The Supreme Court took the case at the end of last June. The case was heard in December. Jack Phillips and Masterpiece Cake Shop make two arguments to the Supreme Court. The first is that to force him to design and bake a cake would violate his religious freedom. If the Supreme Court follows precedent here, this claim should lose. There's a 1990 Supreme Court case, Employment Division versus Smith. It involved Native Americans in the state of Oregon who wanted to use peyote as part of their religious rituals. Oregon law prohibited the consumption of peyote, hallucinogenic substance. The Native Americans brought a challenge based on free exercise of religion. But the Supreme Court, in an opinion by Justice Scalia, ruled against them. The court said the Oregon law prohibiting consumption of peyote is neutral in the sense that it wasn't motivated by desire to interfere with religion, and it applies to everyone. It's of general applicability. The court said the free exercise clause can't be used to challenge a neutral law, one not motivated by desire to interfere with religion, of general applicability that applies to everyone. The Colorado statute that prohibits discrimination by business establishments is neutral, wasn't motivated by desire to interfere with religion, and it's of general applicability. It applies to everyone. So both liberals and conservatives think if the Supreme Court follows precedent, the religious claim can't work in this case. But there's another claim that's much more frightening. Jack Phillips says that he is a cake artisan. That's what he says in his first line of his petition for review in the Supreme Court. And he says to force him to bake a cake would be impermissible, compelled speech in violation of the First Amendment. But if baking a cake is speech, then, as there was a case in New Mexico, taking pictures at a wedding is speech. Then, as there was a case in Washington State, making floral arrangements for a wedding is speech. Then, as Justice Kagan said at oral argument, putting someone's makeup on is speech, because they call themselves makeup artists. In fact, then, isn't almost any work a form of speech? If baking a cake is speech, surely cooking food is speech. One of the most important Supreme Court cases with regard to race involved a restaurant in Alabama called Ollie's Barbecue that refused to admit or serve African American customers. And it claimed a right to discriminate. It lost in the United States Supreme Court. But if baking a cake is speech, then cooking food is speech, then shouldn't it have the First Amendment right to discriminate? If the Supreme Court rules in favor of Masterpiece Cake Shop, it's now creating a loophole to every civil rights law ever adopted. Justice Breyer said this at oral argument. He said this would create an exception for every civil rights statute adopted since day 2. I have no idea why he picked day 2 in his comment, but that's the point. Or to put it to you another way, there's inherently a tension between liberty and equality. Every law that stops discrimination limits the freedom to discriminate. But we've made a choice as a society, at least for a half century, that stopping discrimination is more important than a right to discriminate. That's what's at stake in this case. I fear here, too, that this is going to be a 5-4 decision with Justice Kennedy in the majority. At the oral argument, Chief Justice Roberts and Justice Alito and Gorsuch left no doubt how they will vote. Justice Thomas asked no questions at oral argument. He never asks questions at oral argument. And Justices Ginsburg, Breyer, Sotomayor, and Kagan likewise left no doubt as to how they would vote. When you think about it, if some of you teach in this area and you teach to your students, you might wonder, ultimately, is the question before the Supreme Court, did the Colorado Court of Appeals get it right when it concluded that bakers can't be choosers? One more case before the Supreme Court this term that you should be aware of, and it'll be argued in April, and it's Hawaii versus Trump. It involves the constitutionality of President Trump's travel ban. And it may say a lot about the attitude of this court with regard to Trump restrictive policies concerning immigration, and in that way have effects on your students and sometimes your colleagues. On Friday, January 27th of 2017, a week to the day after being sworn in as president, President Trump issued an executive order that he himself has referred to as the travel ban. It suspended all immigration from 7 designated countries for 90 days. It suspended the refugee program for 120 days. It cut the number of refugees to be allowed in the country in a year from 110,000 to 55,000. It created an exception to those of minority religions in these overwhelmingly Muslim countries. It applied even to those who had the right to be in the United States because of having green cards and visas. You might remember the next day, Saturday, January 28th, lawyers across the country going to airports with their laptops to represent individuals who had the right to be in the country being excluded. It was a day where I was very proud to be a lawyer. Very quickly, federal courts across the country issued preliminary injunctions. Federal District Court in Washington State issued a nationwide preliminary injunction on the ground that this was religious discrimination. This was the Muslim travel ban that Donald Trump had said he'd institute as president. In fact, Trump's advisor, Rudy Giuliani, went on TV that day and said he had drafted it, having been asked by the president to come up with a Muslim travel ban that might get through the courts. The Ninth Circuit affirmed the preliminary injunction. This travel ban never went into effect. The Trump administration did not seek Supreme Court review. Instead, they drafted another version of the travel ban 2.0. This applied to 6 countries. They took Iraq off the list, but it suspended all immigration for them for 90 days. It suspended the refugee program for 120 days, cut the number of refugees from 110,000 to 55,000. It took out the exception for those with minority religions, and it didn't apply to those with green cards or valid visas. Quickly, federal trial courts issued a preliminary injunction saying it was likely unconstitutional. Quickly, federal courts of appeals upheld the preliminary injunctions. The United States Court of Appeals for the Fourth Circuit, an opinion by Judge Roger Gregory, said, "This executive order is dripping with religious animus against Muslims and is unconstitutional." The Federal Court of Appeals to the Ninth Circuit, as the suit brought by Hawaii, said it violated a federal statute that said that the government and immigration policy cannot discriminate on the basis of national origin or country of residence. On Monday, June 26, 2017, the Supreme Court granted review in these cases and set oral argument. it was to be on October 10th, 2017. But by then, the 90-day period had lapsed, and the 120-day period was about to lapse. The Supreme Court took the cases off the docket and then dismissed them as moot. The Trump administration then instituted the third version of the travel ban 3.0. This applies to some of the same countries as the initial one, but they added into this travel ban North Korea, Venezuela, and Chad. Now, you might wonder how many people come to this country each year from North Korea. I researched it. 18 is the answer. And I have no idea what Chad did to get itself on this list. Quickly, a federal district court in Hawaii and a federal district court in Maryland issued preliminary injunctions. The Ninth Circuit upheld this in the case then called Hawaii versus Trump. The Supreme Court granted review in that case. Subsequently, the Fourth Circuit upheld the preliminary injunction, and that case is not before the justices now. They're holding it until they decide Trump versus Hawaii. This is about the scope of presidential power with regard to immigration. This is about the ability of the government to discriminate against people on account of their religion. But it's also, I think, going to be about, as I said, the attitude of the Trump administration with regard to immigration. There's a lawsuit pending right now, and I'm co-counsel, that was brought by the University of California, among others, challenging President Trump's repeal of the DACA program. There's lawsuits pending right now about the constitutionality of the Trump administration's threatening to withhold funds from local governments that adopt sanctuary status. What the court's going to do in Trump versus Hawaii will likely give us an indication of what's going to happen in that litigation as well. Fifth and final observation. What about the longer-term future of the Supreme Court? Did you know that since 1960, 78 years old is the average age which a Supreme Court justice has left the bench? As we're together today, there are 3 justices who are 78 or older. Ruth Bader Ginsburg turned 85 a week ago Thursday on March 15th. Anthony Kennedy will be 82 on July 23rd. Stephen Breyer will turn 80 on August 15th. I have no doubt that Justices Ginsburg and Breyer will stay on the court to the end of the Trump presidency if their health allows them to do so. I've heard many people remark that Justice Ginsburg appears quite frail on the bench. I first met her in 1986 when she was a judge on the Federal Court of Appeals in Washington, D.C. She looked really frail then, too. I have to believe that Justice Ginsburg and Breyer left instructions to their clerks. If anything happens to them, just keep them on the bench and keep voting. But there were rumors that Anthony Kennedy is considering retiring as soon as this summer. Anthony Kennedy is very much a pro-management, anti-labor justice. He makes that clear in all of the rulings, most recently made it clear in the oral arguments in Janus. But whoever President Trump picks to replace him if there's a vacancy is sure to have those same views. And Justice Kennedy is the 5th vote still to uphold Roe versus Wade. I have no doubt that Chief Justice Roberts and Justices Alito, Thomas, and Gorsuch would vote to overrule Roe if they had the chance. Justice Kennedy is the 5th vote to continue to allow affirmative action, race-conscious remedies for past discrimination. Justice Kennedy is the 5th vote to continue the exclusionary rule when the police violate the Fourth Amendment. If Anthony Kennedy, or for that matter Ruth Bader Ginsburg or Stephen Breyer, is replaced by President Trump, it will create the most conservative Supreme Court, the court most hostile to labor that we've seen since the mid-1930s. So this is the context. I realize that I have painted a bleak and depressing picture. It is our reality as we're together in March of 2018. On the Monday after the November 8th elections, the students where I was then teaching, UC Irvine, held a program, and they asked me and several other faculty to speak. And I talked for them about why I'm more frightened now for the country and for the things that I believe in than any time in my life. But then I said to the students what I say to you. We really only have two choices: to give up or to fight harder. And that then means, in light of all that I've talked about this morning, in light of all that you discuss here at this conference, that we really only have one choice. We have to fight harder and better than we ever have before. Thank you.